Many people around the world admire Scotland for its vibrant and unique culture, stunning landscapes, its world-class food and drink, including whisky, and its warm welcome to visitors. And everyone's lives have certainly been touched in some way by world-leading Scottish inventions, which include not only the television and telephone, but MRI scanners, ATM machines, and even the flushing toilet. So it may come as a surprise to many to learn that Scotland ceased to exist more than 300 years ago. And this view is shared by one of Scotland's top legal minds, Robert Black, KC, the architect of the Lockerbie trials held at Camp Zeist in the Netherlands. Ironically, Black was from Lockerbie, the town which would have such an impact on his legal career in later years. He qualified as an advocate in 1972 and became a QC in 1987. In January 1981, he was appointed to the chair of Scots law at Edinburgh University and served as a temporary sheriff between 1981 and 1994. Over the years, Robert Black has acted as the Law Society's examiner in evidence, and he was the general editor of the Laws of Scotland Stair Memorial Encyclopedia from 1987 to 1996. Until 2024, Robert Black also believed that the creation of the United Kingdom came about as a result of two countries, England and Scotland, ceasing to exist and forming an entirely new state, the United Kingdom of Great Britain. But Robert Black no longer believes this. So, what's changed his view? Our guest in this edition of Straight Talk is Robert Black, KC. But before we get Robert Black's legal opinion, please like and share our films, and subscribe to the Scotland channel on YouTube. That way you can help to support independent Scottish media without the gaslighting of Anglo-British mainstream media. Robert Black, welcome to Straight Talk. Tell us, if you will, a little about your thoughts on the constitutional position of Scotland.
I, for my 60 years involvement in the law, have tended to believe what has become the orthodoxy about the constitution of the country we live in. And that is that what happened in 1707 was that two independent states in international law both ceased to exist, and a new state, an absolutely new state, called Great Britain, came into existence. Now that is the version of what happened in 1707 and thereby. That has been accepted by constitutional lawyers, by international lawyers, and by Scottish lawyers for generations. And it is what I believed implicitly until less than a year ago. And less than a year ago, I was encouraged by Sarah Salyers and others just to have a look at what the situation actually was. Like most lawyers, I tend to look at the documentation. And it's the documentation that tends to inform your opinion of what legally happened. But if you look beyond the documentation to what actually happened to the institutions of government in Scotland and in England, then you pretty rapidly come to the conclusion that while Scotland ceased to exist as a state in international law, its institutions of government, legislature, executive, and to a certain extent, judicial branch of government, all of these ceased to exist or were completely transformed. When you look, however, at what happened to England at the same time, the conclusion you come to is that nothing changed. The institutions of government of England, Parliament, executive government, court structure, nothing changed at all, except that the territorial extent of their authority was increased to embrace also Scotland. When one looks not simply at the documentation, but at what actually happened in consequence of the documentation, the conclusion is inevitable that one country ceased to exist. The other country did not, but for cosmetic reasons, changed its name and increased its territorial extent. That is a conclusion that I was extremely reluctant to come to. It ran counter to everything that I had believed for the 59 years in which I had been involved in one capacity or another in the law. But it's a conclusion that I have come to, and which I have no doubt is the correct conclusion in law.
The Bill of Rights of 1689 established the doctrine of parliamentary supremacy in England, meaning that Parliament became the supreme source of lawmaking over the English monarch and the courts. However, during the ill-fated UK Supreme Court ruling of 2022, the Supreme Court ruled that Westminster was sovereign based on the 1689 Bill of Rights, which applied only to the English Parliament, which was allegedly abolished in 1707 on the supposed creation of the UK Parliament. Does this mean that no new British or UK Parliament was ever created? It was just a continuation of the English Parliament and business as usual for England, with Scotland added to its territory?
That is absolutely right, and that is what, in McCormick against the Lord Advocate, Lord Cooper was reaching towards. He never, in my view, actually got there, but he was on the road towards that particular point. And if an entirely new creature as a legislature came into being in 1707, then why assume automatically that it has all of the powers of the Parliament that it succeeded to? Why? It doesn't make sense. Parliamentary sovereignty makes sense under our Constitution only if what exists today is a continuation of what existed in England at that time. It otherwise makes no legal sense. I mean, it's perfectly possible to hold two contradictory views at the same time. Lawyers are actually quite good at that. It can't make both of them right. One of them, if they are contradictory, then one of them must be right, the other must be wrong, or both must be wrong. There is that alternative too.
The oath that those appearing in court have to swear is to tell the truth, the whole truth and nothing but the truth. But clearly it would appear that the Scottish people have been lied to. But have Scots also lied to themselves about the true nature of Scotland in this union, and why? Is this broadly in line with your own thoughts?
Yes, but I wouldn't necessarily think that, and I'm sure you're not suggesting, would be the sole explanation. I think a lot of lying took place, and I have to say, much of that lying did not take place in the early 18th century. If you look at the early 18th century, if you look at writers, both in Scotland and in England at that time, not all of them swallowed the idea that two countries both ceased to exist and a new country emerged like a phoenix out of the ashes. It's only really in the 19th century. In the 19th century, you find a new idea, a new consensus arising as to what happened. And the name that is always mentioned in this context is Professor A.V. Dicey. And Dicey's view of what happened at the time of the abolition of the Scottish Parliament and other Scottish institutions was precisely that English institutions also were abolished and something entirely new came into existence. Now, one can see the attraction of that even for Scotland, because for Scots lawyers who regard themselves as Scottish and not necessarily primarily as British, it is less damaging to one's self-esteem to say that not only our country ceased to exist, but the other lot's country ceased to exist as well. And we became partners, maybe junior partners, and badly treated partners, but it was a partnership. That is more comforting to one's self-esteem as a Scot than saying we actually were taken over by our southern neighbour. So that, I think, is the reason why. I mean, people like Professor T.B. Smith of Edinburgh University, David Walker of Glasgow University, Scottish legal nationalists, but that was the view that they took of what had happened. And I think that's the reason why they took it. It is more comforting to your self-esteem than to recognize that, you gave up your status as a citizen of an independent country to become a colonial.